There's a lot of complicated points in litigation process that use a lot of complicated legal language. And one of those points in the litigation process is a potential motion for summary judgment. And sometimes we will have a defense firm file a motion for summary judgment against all or a portion of our case. And we may use them sort of offensively as well if the case warrants it. But most of the time, these motions are coming in a defensive context. And we might contact a client and say, hey, we're anticipating a motion for summary judgment on this issue, or we received a motion for summary judgment and we have to respond to it. And I think the client on the other end is saying, I don't know what those words are. So we take our time and explain, this is what this means. A motion for summary judgment is a point in the case where enough discovery, so enough questioning between the attorneys and presentation of witnesses for depositions has occurred that there is a basis, the defense would claim, that to dismiss this case without having to continue with it. So that's what the whole summary portion means. It's summary judgment. We're doing this early. We're doing this without having to incur additional time and expense of litigation. And the reason that the basis for that is that there is essentially there's no dispute about a material fact in a case that would reasonable minds, reasonable jurors could disagree on that would allow for that case to be dismissed. This might essentially what they're claiming is that we have not put on enough evidence at this point. We've done enough work on this case that the plaintiffs are unable to make their case either because they don't have the evidence or as a matter of law, their claims cannot be proven here, and this case should be dismissed. So that's something that I think that we anticipate in certain types of cases more than others. In a car wreck case, we don't typically see them. We might see them on individual issues or maybe with individual plaintiffs, but not on the case as a whole. Where we do see these, and this is the context where we have lost on summary judgment motions. I'm not afraid to say that because I think anybody who litigates at the level that we do is going to lose from time to time. That's going to happen. If an attorney tells you they've never lost, then I wouldn't trust that attorney. But we've lost on motion for summary judgment, specifically on cases, slip and fall cases. I think that's where we're seeing these motions filed because it is our job to show in a slip and fall case that the other side had knowledge of the defect that led to the slip. And if we can't show that, then the case might be dismissed on summary judgment because we don't have enough evidence that the other side knew that this hazard exists and failed to do anything about it. Sometimes one context that I recall where this came up is an instance where there's a spill and we can't show that spill we couldn't show that spill had happened in the same time frame that the floors were supposed to have been cleaned. And that's very common, I think. But we take these cases and we trust our clients and we bring these cases as far as we can. We're not afraid to take them deep into litigation through the discovery process and in an attempt to get these cases resolved. But there are instances where we know, look, we're going to have a lot of trouble with this issue because we're not confident that we can show it. We will take our best shot for our clients. We're always going to do that. And there are going to be instances where, the ball goes foul and we strike out. But we also understanding that process means that we have to build these cases strong from the beginning. We're never going to let a case get to this point where there's a potential motion for summary judgment and we haven't done our homework, where we haven't looked under every stone in order to show that we have every piece of evidence in order to support our case so that it doesn't get dismissed on a motion for summary judgment. But other times where we just can't collect enough evidence, things have gone, they were just never collected they were just never available in the beginning. Yes. And unfortunately, that might mean that we're going to lose at some point in that case. But will we not fight as hard as we can in order to get our clients some sort of compensation? Absolutely, we will.